order of the day, number 1.
Bureau and related legislation amendment bill, committee stage continued.
Point of order, the Honourable Trevor Mallard.
Mr Speaker, I move that it be an instruction to the Committee of the Whole House on the Government Communications Security Bureau and related legislation amendment bill that it reconsider Part 1 of the bill for the purposes of considering and, if it sees fit, adopting the amendments in David Shearer's name set out on Supplementary Order Paper 305 to prevent access to the content of New Zealanders' emails unless absolutely necessary under Section 8A. Mr Speaker, speaking to the question, the Supplementary Order Paper will prevent access to the content of the emails under Section 8A of the bill. I think we could probably give a signal this is a debatable motion, Mr Speaker.
Order. Would the member just carry on?
Well, Mr Speaker, I was just being kind to the staff. Otherwise, the staff could be there for an hour or so, Mr Speaker.
I'll equally assist there. That's not the member's job. Will the member continue with his contribution?
Thank you, Mr Speaker. So what this supplementary order paper will do will prevent access to the content of the emails under new Section 8A of the bill unless absolutely necessary. Neither the Government Communications Security Bureau Act 2003 nor any of the amendments that are currently in the Prime Minister's name offer such a protection. This supplementary order paper would legislate to make Parliament's intent clear and New Zealanders' expectation that the contents...
I apologise to the member. Point of order, the Honourable Gerry Brownlee.
Mr Speaker, I assume that we are entering into this debate on the basis of Standing Order 173, which does make it clear that someone can move that an instruction is given to the Committee of the Whole House. What it also says is that any debate on the question for an instruction is restricted to the subject matter of the motion, not in this case the SOP that Mr Mallard is speaking of. It may not extend to the principles, objects or provisions of the bill or any other matter which the motion relates. Mr Speaker, that makes it very clear that Mr Mallard's current content is well outside standing orders. He should simply be making a case for the House to consider his motion as it's written, not the various reasons that might be behind his choosing to move this today.
Speaking to the point of order, Mr Speaker.
Speaking to the point of order, the Honourable...
And Mr Speaker, that's exactly what I was doing. What I was explaining to the House was what was in the SOP. And Mr Speaker, I was not debating the merits of it. I was not debating the merits, but I was speaking exactly to the question which I had proposed to the House. And Mr Speaker, if you remember exactly what I said, it was...
Order. I don't need to hear that. But can I say to the member, Mr Brownlee is right to point out this is a very narrow debate. I will follow very closely the contribution from the member and will expect that he'll be within standing orders. I invite the member to continue.
And I think I agree with you, Mr Speaker, that it is a relatively narrow motion, and it's a relatively narrow question, and it is actually quite a narrow amendment. It's a very specific amendment, and the reason that we need to deal with the question now, Mr Speaker, rather than previously, is that it has become clear from the statements of the Prime Minister, from the statements, including a very good article by Audrey Young in the Herald, where the Prime Minister's lack of understanding on the bill became clear. Mr Speaker, and on this specific question, because what the Prime Minister indicated since the last time the House was in committee, Mr Speaker, was that there was an arrangement whereby he would be trusted in order to...
Point of order, the Honourable Gerry Brownlee.
Mr Speaker, this strays once again well outside what is permissible for a debate of this nature. Mr Speaker, I say again that the subject matter of the motion is what this is all about. Mr. Speaker, for Mr. Mallard to start straying into what he believes was some particular revelation from a Herald article, etc., does not meet the test of these standing orders.
Mr. Speaker.
Speaking to the point of order, Chris Hipkins.
Mr. Speaker, I've had a chance after Mr. Brownlee's first intervention to look at this relevant Speaker's rulings and refer you particularly to page 81 and the first ruling on that page, which makes it clear that the only matter under debate is whether the committee should have the power to examine and adopt this supplementary order paper. So therefore it's perfectly in order for a member moving such a motion to outline the reasons why the committee should have the power to consider that supplementary order paper.
Invite the member to refer to that Speaker's ruling again.
81(1).
Right.
So the procedural motion, that's the second part of it. The only matter under debate is whether the committee should have the power to examine and adopt the supplementary order paper. So it's important, therefore, that a member needs to be able to explain why the supplementary order paper should be debated.
I think, in fact, now the point raised by Chris Hipkins has very much strengthened the point made by the Honourable Gerry Brownlee. The member, Honourable Trevor Mallard, must remain very tight in his debate, and frankly tighter than he was when he before he resumed his chair.
Mr. Speaker, I'm going to try and take the point that I had begun to make to the point where you can understand and the rest of the House can understand its relevance, sir. The situation has moved since the House last debated this issue. And that is why, Mr. Speaker, I am suggesting, and the Leader of the Opposition has an SOP that involves, I quote, that it reconsider Part 1 of the bill for the purposes of considering the supplementary order paper. And I'm explaining how the world has changed. The world has changed, Mr. Speaker, with 2 points. First of all, the Prime Minister made it clear in the Herald that there was an element of trust me in this. And Mr. Speaker, what the opposition are saying is that, given that is the Prime Minister's approach, that we will accept him at his word and we will reinforce that, Mr. Speaker, with the SOP.
Order. Honourable Gerry Brownlee.
We're straying into a justification for the SOP. The question simply is, should the House recommit time or go back to consider a bill that was given a considerable amount of time last week because of some revelation that Mr. Mallard and his colleagues seem to have woken up to, or have decided, more importantly, sir, to make some interpretation of. Mr. Speaker, it is absolutely essential that for matters like this, where the House is extending the right understanding orders to recommit the House to a particular course of action, to instruct the whole House, that we do stick tightly within the rules of debate. Mr. Mallard is not doing that.
And I invite the member now, the Honourable Trevor Mallard, to continue his contribution, but he must tighten it up. Otherwise, I will have no choice but to end the member's contribution.
Okay.
Honourable Trevor Mallard.
Mr. Speaker, the reason the House needs to reconsider Part 1 is because since it considered Part 1, new information has come to hand. That new information came to hand in 2 ways, Mr. Speaker. One, a statement quoted by Audrey Young in the Herald from the Prime Minister as to his understanding of the legislation. That was something which was different, which differed from what had been previously said about the legislation by the government. The second, sir, is the indication that the Prime Minister has made that it is his opinion that a comment that he can make at the 3rd reading will be something that is interpreted in the court over and above what is in the substance of the bill. Mr. Speaker, that comment has also been made since the House was last debating this in committee. Mr. Speaker, on the latter point, I think I'm probably one of the few members who has been cited in the court as a result of comments made in the House as to the interpretation of a bill at the time and an act now. And, Mr Speaker, what the court made clear at that time was that the comments were useful in interpreting a particular section of the Act, but, Mr Speaker, what is also absolutely clear is that that section of the Act has to actually exist in order for the courts to interpret it. And the proposal here, as part of the reconsideration that has been suggested by the Labour Party, and I understand being supported by a number of other parties, is that because this new information is available, what we should do is put in front of the House a question where the House can decide, and I think possibly even unanimously agree. I mean, I want to make it very clear, Mr Speaker, that nothing that I'm saying now will indicate that the Labour Party will support the bill, even if this amendment, even if Mr Shearer's, but just to make it clear, this is a reconsideration of a particular matter to improve the bill, to pick up the government's suggestion made since the House was last in committee. We want to pick up their suggestion and to get something, it's sort of, Mr Speaker, we're from the opposition and we're here to help. And what we're trying to do, Mr Speaker, is to get the bill into the form that the Prime Minister over the weekend, or certainly in the period since the House last sat, indicated that he wanted the law to be in. So what this supplementary order paper does, and it's supplementary order paper number 305. Sorry, I apologise. And in fact, Mr Speaker, I'm sure my colleague will move an amendment to my motion because somewhere between the morning and the afternoon, the supplementary order paper in the name of David Shearer changed its number from 305 to 331. Sorry?
Order.
Well, they're different sizes of snapper. And if Mr Brownlee, I'm sure Mr Brownlee doesn't think it's fair that commercial fishermen take that.
Now we are.
Well, if I'm not allowed to respond to an interjection from the Leader of the House. Mr Speaker, that was an invitation from the Leader of the House to focus on the question of snapper. Mr Speaker, but the point that I am making is the same point that the Prime Minister was alluding to since the House last sat, and that the question was whether Kiwis are worried about this, and in particular the very narrow question, Mr Speaker, about when their emails are picked up as a result of the cyber surveillance, the cyberspace surveillance, and that's the area that we're talking about, whether there should then be the right to open them up. And so there's an SOP which sits in here, and I'm not going to the merits of it, but what the SOP does, Mr Speaker, is make it clear that is not a ground for opening those particular warrants, and that consent is necessary. And Mr Speaker, I just again want to somewhat go back over the area that I have traversed and say that this is exactly the practice that over this last weekend the Prime Minister said that he wanted. The Prime Minister said that he wanted the legislation to be interpreted in a way so that New Zealanders' consent would be obtained before their emails, which are obtained as a result of the megadata cyber surveillance clauses in the bill, that he would get their consent in order to have them looked at. Mr Speaker, again, it is relatively unusual for the opposition to be tidying up after the Prime Minister. I think that we had some debate about whether we should just sort of leave the question for the courts to interpret, because, as I indicated earlier, and I'm absolutely certain that the Attorney-General will advised the Prime Minister that it's better to have something in the particular act that goes through rather than just a comment in his third. Well, this is exactly the point, Mr. Speaker. I know you're telling me to come narrow, but I am being very, very specific about the comments that were made over the weekend by the Prime Minister about his intention in this particular area to have this clause, this very clause, not written into the bill but written into his third reading speech. Mr. Speaker, this is Parliament. This is the Parliament of New Zealand. We pass the laws. They aren't dictated in a speech from the Prime Minister.
Order. Just in relation to that last interjection made by the Honourable Trevor Mallard, it wasn't that I was telling him to get narrower, it was just that the speech was becoming highly repetitive, and I give that as a warning to all other people that contribute. The question is that the motion be agreed to. Honourable Gerry Brownlee.
Mr. Speaker, the reality of everything that Mr. Mallard has said in support of his motion is that nothing has changed in the bill or otherwise from last week, when the House gave this particular part of the bill a very considerable amount of attention. Mr. Speaker, to make a case which effectively says over the weekend we woke up and had another good idea and therefore we want to delay the passage of this bill as long as possible by instructing the committee to go back onto areas that it's previously covered, is completely inappropriate, Mr. Speaker. One of the things that I think stands out here is the claim by Mr. Mallard that any comment made in a speech in Parliament has no relevance to any piece of law. Mr. Speaker, he is not the only member who's found himself quoted at various times by judges who've considered how a piece of law is to be interpreted. So, Mr. Speaker, that is a spurious argument that is being mounted in favour of reserving the House an additional amount of time for this Part 1 consideration. I'd also say, Mr. Speaker, that when the House does spend so much time on one part on one bill, and when the speaking arrangements for that part are so heavily weighted toward those who are opposing the part, it seems quite unreasonable having the House make a decision in favour of that part. Those who oppose it should come back in here and say, look, we want to have another go. We want to take some more time. What this is all about, essentially, Mr. Speaker, is trying to back up Mr. Shearer, who found himself in front